rest assured that they will be meaningful once ordered by the court.
Mr. Speaker.
David Clendon.
Thank you, Mr. Speaker. Could I just begin my comments by endorsing Mr. Little's remarks about the need for a comprehensive review of all of the legislation, all of our practice around protecting and restoring victims. That's something that the Greens look forward to working with Labor next year when we have a new government. In the meantime, sir, to address this bill, the Greens are supporting this bill, albeit with some reservation. I was on the Select Committee, I voted for it. I sort of stand alongside it we didn't do a minority report, any of those things. But we still have some concerns about the bill, some of which we might seek to address at the committee stage. We're supporting the bill primarily because there clearly is a gap. It's perverse in a sense that a person who's been the victim of violence from a family member, I was going to say a friend, but that's the wrong word, so an associate, somebody close to them, can get the mechanism of a protection order, but somebody who's been seriously assaulted or abused in some way by a stranger doesn't have access. And that is the gap that this bill seeks to fill, and we think it's appropriate. And clearly there are cases, the historical cases, that have demonstrated the need for some sort of mechanism to add a layer of protection and indeed to add a layer of comfort to the victims of what are going to always to be serious crimes in this sense. Sir, I think some of the issues that I want to talk about with the bill may become apparent over time. I'd love to be proven wrong. This might be seamless and without flaw, and that would be a good thing. But I do think that maybe there's a few things that we have still got wrong in this. Primarily, I'd say that part of what this bill does is actually already covered by law. Some of the conditions that would be imposed on a person subject to one of these orders already exist. I'm quite sure already that if I had been an offender who had assaulted somebody, if after release I was found to be loitering around their house or watching them, obstructing them, leaving objectionable material where they may find it, encouraging somebody else to do some form of harm to this person, I'm quite sure that existing law, that in fact that the police would very quickly be on the case and be responding in some appropriate way to that sort of behaviour. So some of what we're doing with this is already covered by existing law, and I do wonder at the necessity for replicating that. Having said that, I do think that the provisions about third-party provisions, if you like, the fact that if I, as an offender in jail or recently released, get one of my dodgy buddies to go around and cause harm or cause grief or fear to whatever, it's entirely appropriate that the legislation should cover sort of that third-party aspect of it. And I think that is one of the strengths of the bill, that it does recognise that it doesn't have to be the primary offender causing harm to a victim. It can be some other person, not least of all in gang situations, but even in situations where there's no gang activity or influence. So I do take Mr. Goff talked about the shift from the 5-year threshold to a 2-year threshold, and he makes a compelling argument that the 2-year threshold does align it with the Parole Act, and that's not insignificant. I still have some unease, and not least of all following the initial briefing we had and the talk of the numbers of people potentially affected by this. 5 years arguably was too high a bar, and there was the one case already referenced where a 4-year sentence was imposed, and that offender would have escaped the consequences or the provisions of this bill. But my concerns about the 2-year sentence, partly there's an issue of cost. That's a secondary concern. It will inevitably mean significantly more cost associated with this. The more compelling concern I have is that we are told that currently, or over the past 5 years, there would have been something less than 1,000 offenders released who would be subject potentially to one of these orders. Something less than 1,000, let's say 800-900, take out a few of those who would already be subject to protection orders perhaps, you're still talking about quite a few hundred of people per year who potentially might be subject to one of these orders. And I have a fear that if they proliferate, if suddenly we're seeing literally hundreds and hundreds of these things in place at any given time, it almost devalues the importance of them, and it certainly puts increased load on the police in terms of enforcement. We have a lot of protection orders out there at the moment, and we know already that we've seen some tragic consequences. Police have reported to them breaches of protection orders. They need to make a call as to the urgency or significance of that. And generally, I'm quite sure they get it right, and I'm quite sure they work very hard to get it right every time. But on occasion, it will, their things will fall through the cracks. They'll be sort of downplayed in terms of priority. And I do fear that the proliferation of these orders will devalue them in terms of enforcement. And there will be situations where there is not sufficiently fast response, because after all, it's only another victim's order. And when you have hundreds and hundreds of these things in force, and almost inevitably we will. So I think that's something we need to maybe give a little bit more thought to. As I say, the cost, the financial cost is certainly a secondary concern, but it's not a trivial one either. The issue of at what point somebody can apply for one of these orders. And in terms of application generally, I think I entirely agree with the intention of the bill, that the application cost should be minimal, should be very, very low, that it doesn't necessarily mean engaging a lawyer, that the application process should be swift, should be straightforward. Obviously, there needs to be an opportunity for the person, the defendant, if you like, to defend themselves, to oppose the notion. But I do think we must make very sure that neither process nor cost is a barrier to the application of these. And I think the language of the bill and indeed of the explanatory note does seek to ensure that. But I do still wonder at the notion that these things can be applied for immediately post-sentence. And again, I think it will result in many more of these orders being applied for and being issued. Because after all, on what basis would a court deny or reject an application for an order immediately post-sentence? If a person has recently assaulted someone with sufficient severity that they're subject to at least a 2-year, or rather more than a 2-year sentence, it's most unlikely that a court would have much grounds to say no. Allowing for the sentence, rather for the order to be applied for and imposed very soon after sentencing, it assumes that the prison is actually going to fail in its job of rehabilitation. Yes, we know that there are often recidivist offenders, people who continually offend, and they are very likely to offend again. But even serious assaults can sometimes be the outcome of a very unique and specific set of circumstances, and highly unlikely ever to be replicated. And I do wonder at the assumption built into this provision that there is no likelihood of rehabilitation coming through a 2+ year sentence. And I do think that that's something, again, we need to have some thought to. The argument made that, well, yes, people can, while still in prison, threaten, cause grief to a victim. Well, that's right, they can, but only because they're breaking the rules. Obviously, corrections works very hard to ensure that prisoners cannot have inappropriate communications outside of prison. And as I said earlier, I think the third-party issue, where an inmate might persuade one of his friends or associates to go and cause grief to this person, I do believe that's readily covered by existing legislation. So I think that we need to get something a little bit more nuanced than immediately post-sentence. The likelihood of a victim wanting one of these orders a short time after the offence has been committed, the person's gone down, right, I've got an opportunity to impose some more burden on them. And then clearly that's going to be something a lot of people will want to do. I fear it could almost become a default position where anybody that's subject to more than a 2-year sentence will find themselves with one of these orders imposed. And I return to that notion of these orders being devalued, the likelihood of them having a status, if you like, or having the sense of this is a very serious matter, that these orders are only issued on the most vile and objectionable cases of assault on people, and that we need to give protection to these people, the victims, to allow them to get on with their lives. There is a balance in that if somebody does come out of prison, perhaps the best place for them in many regards would be returned to that community within which they offended, albeit with some protections and some comfort for the victim. So, sir, I think, as I say, we're supporting this and we will continue to support it because there is a gap, but we have some concerns and we'll address those in committee. Kia ora.
Mark Mitchell.
Thank you, Mr. Speaker.